for dissolution of marriage under statutory framework for that action. So we are dealing with G and H today. Can somebody read G to us? Hello? Hello? Can you hear me?
Hello,
okay,
Mama.
Okay, excellent. Please, can somebody read G? Fact G of section 15.2.
Section 15.2G.
Yeah.
That the other party to the marriage has for a period of not less than 1 year failed to comply with a decree or restitution of conjugal rights made under this act.
Okay, can somebody read section 47 of the act to us? The Matrimonial Causes Act, section 47.
Section 47. Ground for decree of restitution of conjugal rights.
Yeah.
A petition under this act by a party to a marriage for a decree of restitution of conjugal rights may be based on the ground that the parties to the marriage, whether or not they have at any time cohabited, are not cohabiting, and at that, without just cause or excuse. The party against whom the decree is sought refuses to cohabit with and render conjugal rights to the petitioner.
Excellent. Section 49. Can somebody read section 49 to us?
Section 49.
Yeah.
Sincerity of the petitioner. The court shall not make a decree of restitution of conjugal rights unless it is satisfied that the petitioner sincerely desires conjugal rights to be rendered by the respondent and is willing to render conjugal rights to the respondent, and that a written request for cohabitation expressed in conciliary language was made to the respondent before the institution of the proceedings, or that there are any special circumstances which justify the making of the decree, notwithstanding that such a request was not made.
Okay, very good. So, thank you very much. What's your name? Because it's not coming out on my own system. Hello?
My name is Favor.
Okay, thank you, Favor. Okay, all right. So, can we discuss this? What do you think generally of these provisions which we have just read? What are your general impressions? Do you understand what we have read now? You know, we started with 15.2G. Then I took you to the exact sections that are making provision for restitution of conjugal rights. Restoration of conjugal rights. That's sections 47 and 49. So I want us to look at it from just ordinary perception. Let's even just look at it and see what is being required here, number one. Number two, is it a rational requirement? Is it something that, you think is rational, even without looking at the cases, without looking at the legal import? What do you understand this to mean? Yes. I don't know. I thought this class was for 2:00. So I didn't realize it's 12:30. So I don't have my laptop. I'm using my phone. I don't know how to see your hands. Do you know how I can do that? See your hands raised.
Hello, Ma. You just tap on the middle of your phone. It should bring out a maybe something like a dialog box where you see mute, start video, participants, chat
Yeah, I can see
reaction.
participants.
Yeah. Then when you tap on the participants, Ma, and then you will see the list of participants, and the list of people who have their hands raised.
Okay, I haven't seen any hand raised now. Thank you very much.
There's no hand raised yet, ma.
Okay, so I'm waiting for hands to be raised on this subject. A favor, can you read again so that everybody can hear you?
Ma, from 15.
Yeah, start from 15 again and read again. 15, 47, and 49.
Okay. Section 15 2G. That the other party to the marriage has for a period of not less than 1 year failed to comply with a decree or restitution of conjugal rights made under this act. Ma, should I also read H or just straight to 40?
Read sections 47 to 49, please.
Okay. Section 47. Ground for decree of restitution of conjugal rights. A petition under this act by a party to a marriage for a decree of restitution of conjugal rights may be based on the ground that the parties to the marriage, whether or not they have at any time cohabited or are not cohabiting and whether or not they have at any time cohabited, are not cohabiting, and that without just cause or excuse, the party against whom the decree is sought refuses to cohabit with and render conjugal rights to the petitioner. That's 47. Then 49. Sincerity of the petitioner. The court shall not make a decree of restitution of conjugal rights unless it is satisfied that A, the petitioner sincerely desires conjugal rights to be rendered and by the respondents and is willing to render conjugal rights to the respondents. B, that a written request for cohabitation expressed in conciliary language was made to the respondents before the institution of the proceedings, or that there are any special circumstances which justify the making of the decree, notwithstanding that such a request was not made. Ma, I'm done.
Ma, I am muted.
We lost her.
So how did you know that I was muted? Hello? And how did you know I was speaking?
I could see.
Huh? Hello? Hello?
Hello,
No,
ma.
how did you know that I was speaking? Since I was...
I could see the vibration from your side.
Okay. I didn't even know that I was muted. Okay, right. So what I'm saying is that this particular fact is very interesting. You know, when we did E and F, which I'm sure you are so versatile with now, both from my own angle and Dr. Adegbite, we thought that one was intricate. Those two were intricate. Now, this G is the one that I find very interesting. So I want us to look at it, first of all, just as rational human beings. Number one, if there was love in marriage between two people, or if there's even a possibility of of this marriage not having broken down irretrievably, why should the law be requesting that the person must have made efforts in writing, conciliatory, to somebody whom one loves and to whom one is married to? You know, some of these provisions are just very pathetic. You know, it's like they took them from 1900.
Please, ma,
Yes?
your network broke at some point, so I could not hear the last statement on the question. Can you come in?
Please, I'm just looking forward to you people returning to school, because this Zoom, I'm tired of it. I don't understand. Sometimes the network, I'm talking, and then my network is breaking up. Anyway, what I'm saying is this. I said that, where did you hear up to? Did you hear up to E and F?
Yes.
At
At the point, I heard up to where you said, why would the court need the spouse to write a reconciliatory letter? That was the last thing I heard.
Exactly. So from there, I want you to start discussing. Now, start bringing out the things you see in the three provisions, starting from 15(2)(g), then go to 47 itself and 49. I want you to think and come up with whether critique or viability of these provisions within the framework of what we are discussing: a man and a wife, a husband and wife. So please, you now raise your hand. Okay, I can see somebody's hand raised. Adeshina, please go on.
I already lowered down. I already lowered my hands down. So I'm trying to think of what's.
Yes. So if Adeshina has lowered hand, then somebody else, you should speak.
Okay, ma. So let me try. Good afternoon, ma. So
Good afternoon.
the section 15(2)(g) gives provision for dissolution where a court order that is instructing reconciliation cohabitation is ignored. So in section 47, it makes provision for the court for someone to apply, someone that wants reconciliation genuinely someone that wants reconciliation and resumption of cohabitation genuinely, to apply to the court ordering the other spouse or the respondent in this case to resume cohabitation. And the court does not in that section, it provides that such a respondent cannot be forced to resume cohabitation. The only legal consequence would be that the petitioner can now use that refusal as a ground for dissolution of marriage, coming under section 15 subsection 2(g). So you said we should critique that. Well, in my opinion, I think that since the petitioner initially does not want the marriage to break down, it is almost counterproductive, because this particular section 47, the court cannot enforce it. And because the court cannot enforce it, it's counterproductive for the petitioner, because at the end, if the other respondent chooses not to, he would just probably have to take the line of dissolution of marriage, which he did not want initially, considering the fact that he wanted reconciliation. And another issue is that this particular section can be used, like, the intent of the drafters of this section was to encourage reconciliation, but people that do not want reconciliation can take advantage of this section. So I think those are the two criticisms I can give.
Okay, why do you think, how can the person who does not want reconciliation take advantage of the section, of the provision?
So a petitioner might not sincerely want reconciliation, and then he might just file it knowing that the respondent will not agree. And of course, this section, it says that the respondent cannot be forced. So it is almost like an easy ground for the petitioner to file under dissolution of marriage.
Exactly, to meet that particular criteria. And then generally, I want you to look at even the provisions, the so-called efforts through the provision to reconcile. Are they reasonable provisions?
I don't think they are, because if a respondent has already been refusing the letter, because it requires that the petitioner should have written a letter wanting reconciliation. So if he has already refused that, then there is it's almost like nothing is going to force him to now follow and obey the court order in this case.
Exactly. So even the requirement itself that the petitioner must have made effort in writing is so ridiculous. It's so ridiculous, because the mere fact that he has to make that effort at reconciliation in writing shows that the marriage itself has broken down irretrievably. I don't know, do you get what I'm saying?
Yes, ma'am.
Although there is the argument on the other side that, well, that effort may force the other person to see reason, to see reason that, oh, maybe actually I love this fellow, maybe, that the process of that effort may make the person see reason. Now, but if that process will make the person see reason, what will now be the necessity for the petitioner to bring a petition to court for that restoration? Do you understand?
Yes, ma'am.
If the effort, if the law is properly grounded, you understand, and the people understand what precisely they are talking about, why would the petitioner now come to court? Do you understand? Because at the point of writing that letter, it should be expected that the respondent would have responded positive to the appeal of the petitioner. Isn't that so? So there will be no need to come to court. Oh, do you not see it that way?
Yes, ma'am, I see that.
It's not only you. Where are the other people? Okay, additional, you want to talk now?
Okay, yes, ma'am.
Okay, go on.
My own interpretation of this provision is that before they can bring a case for dissolution of marriage before the court, they must have written a petition of conjugal rights, and that one of the parties must have refused within a period of less of 1 year. So, and the restriction of conjugal rights has to do with living together. So I think it also brings the provision of section 2A and the part of living apart. I think it also brings that together too.
So you think that it is okay to have that provision as a basis for dissolution of marriage? Don't you think it's an abuse of court process and waste of parties?
Just what I'm saying.
Sorry?
I didn't hear you.
I said, you think, from what you're saying, you seem to support the fact that that provision is there in our law. Isn't that what you're saying?
Yes, ma.
But do you not think that if you look at it critically, there is a kind of waste of time of the parties and waste of court processes, abuse of court processes, and that perhaps this is one of abuse of court processes, and this is one of the reasons our courts are always jammed, because there are useless provisions, a lot of useless provisions in our laws. I'm just asking.
Yeah, I think so, because if they've gone through the reconciliatory process, yes, I think so.
And again,
so, because if they've gone to the reconciliatory process and one of them at that point still says that it should exist. I can't hear you, ma.
I'm not speaking.
Okay. So I said, I think it's a waste of court process, because if they've gone through the restitution reconciliatory process and one of the spouses says he or she doesn't still want the marriage, it's just useless to come to court and still try to dissolve the marriage. You should have just ended it there.
Even the restitution of conjugal rights itself, why should the court be concerned with such a decree? Don't you think the law has no basis for even having that provision, the provision in section 47 itself? Do you think it's a sensible provision to have in our laws? If you are having to beg a man and a wife for them to come to live together, is there anything still left in that marriage?
No, ma. But I think, I think they are the ones who brought their cases to court. So they are, it's somehow.
The idea is that Do we have the time and the resources for all this kind of waste of time, for the parties? At any rate, let me hear somebody else. Who else wants to speak?
Hello, Ma.
Yes, you can go
Elma,
on.
good afternoon, Ma. Okay,
Good
so
afternoon.
I think the whole essence of that section is that, I believe that maybe the whole aim is that courts do not, or maybe they are not really interested in the dissolution of marriages. So they are just trying to look for ways to ensure that marriages, stay. Because the whole essence of the decree is to ensure that, okay, maybe during that period, you guys realize that you still love each other, you enjoy your company and all that, and then you decide to still stay together. But I feel that it's not exactly beneficial or effective. That's the word. It's not exactly effective because there are still people that, there are situations where, okay, people end up, fulfilling the decree and they stay together only for one person to just continue making the person that was not in agreement at first to just continue making the life of the other miserable. There are situations where, because of, oh, well, let's just fulfill this decree. What would people say and everything? They just end up staying in the marriage and then it becomes emotionally abusive and just generally abusive for both of them. So I think the court, this provision is doing more harm than good if you are trying to encourage parties that are done with a marriage to just persevere and stay together, because the truth is that for those people that have marriages of 20 years that they too might have opportunity, or they thoughts might have crossed their mind that, oh, I don't like the way my partner is. But there must have been something that caused them to stay for that long. But if we are having marriages on the other hand, where both parties are looking at it that there really isn't anything for me to hold on to in this union, there really isn't anything for me to, hold on to look forward to in this marriage. I just feel that it's beneficial. Let them just go their separate ways rather than cutting them to each other. And then if they then decide, okay, let's come back together, and then along the line, like Kendi said, along the line they decide, oh, we are no more doing this again. We are tired of this. Do they still, like, they'll still need to go back to the court, fresh institution of an action, and they'll petition afresh and everything? It's wasting time. It's wasting court processes. It's wasting paper, and basically it's probably the lawyer that will just enjoy it because, oh, of course I'll be
Exactly.
getting my money. But really, it's just a wastage of court processes, and it's just something that we can avoid if the provision is scrapped out.
And again, do you notice the subjectiveness of the court to grant all of these things? The fact that the discretion that the court has is so wide. How do you determine the sincerity of the party? Just like the first person said, I don't remember now whether it's Kehinde that said it. Somebody said that the person who wants the marriage to end may actually be the one who will go and petition for that decree, so that by the end of 1 year, he will just appear in court and say the other responded refused to. Do you understand? So if you just want to take advantage of that particular provision, I think it was Kehinde who said that. So the discretion that is vested in the court is actually so wide. Because how do you determine the sincerity of the party? You say, okay, the person must show evidence. Even the very day you are going to court to file the process, you can write the letter. Assuming you don't even you write it 2 weeks or 3 weeks before that, and you write the letter knowing fully well the respondent will not accept. You just write letter for the purposes of, the court, for the purposes of your petition in court. And do you also see something? What is the difference between, in substance, I'm not talking of in principle, in substance, between this provision and fact D? Favor, can you read D to us?
Okay, ma. Section 15C.
D.
Okay, section 15D. Section 15D, that the respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition.
In substance, I'm asking you to think now. In substance, what's the difference between this and G? And then Favor, read section 13. Read section 13 of the Act.
Section 13. Statements, etc., made in course of attempt to effect reconciliation effect reconciliation. Evidence of anything said or of any admission made in the course of an endeavor to effect a reconciliation under this part of the Act shall not be admissible in any court, whether exercising federal jurisdiction or not.
Start from
or in-
11. Start from section 11.
Okay, ma. Section 11, reconciliation.
Mhm.
So 1. It shall be the duty of the courts in which a matrimonial cause has been instituted to give consideration from time to time to the possibility of a reconciliation of the parties to the marriage, unless the proceedings are of such a nature that it would not be appropriate to do so. And if at any time it appears to the judge constituting the court, either from the nature of the case, the evidence in the proceedings, or the attitude of those parties, or of either of them, or of counsel, that there is a reasonable possibility of such a reconciliation, the judge may do all or anything of the or any of the following. That is to say, he may adjourn the proceedings to afford those parties an opportunity of becoming reconciled, or to enable anything to be done in accordance with either of the next two succeeding paragraphs. B. With the consent of those parties, interview them in chambers, with or without counsel, as the judge thinks proper, with a view to effecting a reconciliation. C. Nominate a person with experience or training in marriage conciliations or in special circumstances, or in special circumstances, some other suitable person to endeavor with the consent of the parties to effect a reconciliation. 2. If not less than 14 days after an adjournment under subsection 1 of this section has taken place, either of the parties to the marriage requests that the hearing be proceeded with, the judge shall resume the hearing or the proceedings may be dealt with by another judge, as the case may require, as soon as practicable. Ma, should I go to 12?
No, it's okay. I just wanted just to look at this and then try to see whether these provisions are reasonable and sustainable in modern conditions. Now, what is the difference between, in substance? I asked you the difference between D and G in the facts of evidence of irretrievable breakdown of marriage. Okay. Now, this restitution of conjugal rights seems to be aiming at reconciliation. And then you have these sections 11 to 13 again that give the court the powers again to process reconciliation. Are all these sections not making the laws just, too wide and without real focus? What do you think? Or you think they are viable? Yes?
Good afternoon, ma'am.
Good afternoon.
Just as you said, yes, ma'am. Just as you said, when I was looking through the provision of section 15.2G, and I found that it's not actually different in substance from this section, because in that 15.2G, that is the same number of time frame, like at least 1 year. Also in MD, it's also at least 1 year. So, and there must have been there must have been lack of cohabitation. So maybe they were staying apart from each other. And I don't see why they need to be 15.2G when we can use when there's already 15.2D. Also,
Exactly.
as regards the reconciliation processes, Section 11 already provides for that. So I don't know why there's also the need to be stating a lot of bureaucratic processes just to confuse parties just willing to dissolve their marriage. And I think that letter.
Yes.
Yes, sir.
Go on.
I think that letter. Yes, I think that letter stuff is archaic and actually redundant, because it's like in this age, telling marriage parties that they have to write letters to each other before they can come to dissolve their marriage, I think is not reasonable. So I think that's my take on it. And so I think the speaking to you. Yes, ma'am.
Yeah, and again,
Yes,
when you look at it, that in modern times, when you look at the laws in terms of right to privacy, right to family life, right to dignity, all of these things seem to be an invasion into people's rights. Do you understand? It seems to be
Yes, ma'am.
it seems to be an invasion into people's private lives, and without constructive gains. Without constructive gains. And more very importantly, our courts are congested. Because like somebody said, I think that was Kehinde again, who said that the people who profit from all this are lawyers. And it doesn't even improve law practice, because the lawyers themselves are nonchalant. They just file rubbish before the court, because the law itself has given room for the filing of rubbish. And the law is so bulky. I mean, before you go through all the provisions of the matrimonial courses, you are looking at one provision. The counsel to the petitioner is looking at one provision, but because the law is chaotic, the total body of the law is chaotic and bulky. The counsel to the respondent is seeing another provision that punctures the provision of the one that the petitioner is holding on to. So at the end of the day, there doesn't seem to be any progress. And this particular provision seems to have been abolished in all the jurisdictions where we took it from. England, Ireland, Australia, all of New Zealand, they seem to have abolished this particular provision, because you can't force somebody. Like we are saying, when this situation has gotten to the point where the court is the one forcing a man or a wife to go and live with the other, there's not, you're probably telling them to go and harm one another. So why should we do that? Okay. Now, can you still hear me?
Yes,
Yes,
ma'am,
sir.
we can.
Yes, ma'am. Yes, ma'am. We can.
Okay.
Sorry, ma'am. I'm sorry, ma'am. I have a question.
Yes.
I don't know. I'm just considering the fact that I understand that from the discussions so far, it seems as if the provisions will be causing abuse of court processes and waste of papers. But then I don't know. The way I'm thinking of, what if there are children from the marriage, and I don't know if the solution comes with the maintenance of the children. Like, for example, now, if the petitioner wants the marriage to be reconciled, and then the respondent does not want it, maybe the petitioner is considering the state of our children or other factors, just basically the children. So I'm thinking that probably why they are calling for those processes to be, why the law is detailed about the process, is for them to look at the children, the maintenance of the children and all. I don't know.
But the court can do that. There are clear provisions for maintenance of children, that you can just come to the court to say, okay, what you are looking for is how the children should be maintained. You don't have to come through dissolution. You don't have to first go through a restitution of conjugal rights to make sure that the parties are living together. It's wholly unnecessary. Do you get what I'm saying? The children's rights are provided for. You can file for that differently,
Okay. Thank
without
you.
having to even go through all this. So generally, well, the bottom line is that we can come to the conclusion that our own framework for divorce is a false regime, even though the ground seems to be showing that our framework is a no fault regime of dissolution of marriage. The facts demonstrate that it's not true. That in fact our law is a fault regime that is looking for fault. That if there is no fault, the court will be unwilling to dissolve the marriage. So all of these other critiques we are making, they are just ways of engaging our mind. But this is the position of the law. The position of the law is that the court has the power to issue a decree for the restitution of conjugal rights. And then the court also has the power that where one party has failed to comply with those with the decree, then sorry.
Maf, good afternoon.
Good afternoon.
So, Ma, is there not a way that or is there not something that can be done to, maybe find a way to maybe abolish these laws, these should I say pathetic laws according to the way you call them, instead of continue using them? Because I feel maybe these laws are like old, very laws made during the military regime or something like that. Maybe that's why it was something somehow pathetic.
Well, it can. That's why we are studying. That's why you are on ground, and we are pointing out all these things to you because even though we are unable to do anything, some of you may end up being in a position to do something. So you may be academic, you write articles, you do things. So, but it's a law. It has to be either amended or abolished, but it's the legislature that will do it. Our own is we're academics, we are teachers, we're just telling you what is on ground and the criticisms. So do you understand? So yes, there are rules. Like I said, this particular provision is no longer in existence in most jurisdictions. Most jurisdictions consider it odious and unnecessary, redundant. But our own law since 1970, nobody has touched it. It has been like that. So that's the position. So I want to give you a case that you can look at on this particular subject matter. I'm trying to, I don't have my glasses. I'm trying to get the case for you that you may find relevant. In addition to other cases you will get. Look at just give me a moment. There's a good case I have on this that I want to refer to. Yeah, a Ejiofor and a Ejiofor. Do you have it? Although it's unreported suit number FCA B4278, Court of Appeal, delivered on May 17, 1979.
Please, Ma, can you help me? Can you help us repeat the name of the cases or the name of parties of the case? I did not get that.
Ejiofor and Ejiofor. Ejiofor and Ejiofor. Ejiofor and Ejiofor. Unreported suit number FCA/B/42/78, Court of Appeal, delivered on May 17, 1979. This at least will give you a sense of how the court views restitution of conjugal rights.
Ma,
Yes.
Ma,
Yes.
Ma have a question.
I want to apologize in advance for this question, but Ma, since it's unreported, how do we get the law report?
You just look for it. You go to our library. Go to our library and look at the unreported cases. You will find it there. There are cases. There are cases that are unreported, but you see the flips. Just ask the librarian. Okay.
Okay, thank you very much, Ma.
Like the case of Marquis and Marquis, Professor Marquis and Marquis, the Nigerian wife and and the professor. The Scottish wife and the professor is unreported, but it's available in our library. There are unreported clips in our library. You understand? But you know, they are not in NWLR and all of those things. That's just what it means.
Okay, ma, thank you.
Okay. So we see that the provision is one that is based on an OTO's position.
I have a question.
Yes, please. Go ahead. Yes. Yes. Who's asking a question? I can't hear you now. Hello?
I
Hello,
think
ma, I
our
have a
network
question.
was.
Huh? This network seems very poor today. Yes.
I said I have a question.
Yes, go
My
on. Go on.
question, okay. My question is that when we say conjugal rights, are we saying the same thing as consortium? Like all the rights in given to spouses in marriage? I want to be
Well, you
sure.
see, it will not, it includes, it covers all the rights. When you say conjugal, it covers all the rights. But in reality, what the court is looking for here is cohabitation. Because the court cannot come into the bedroom to find out whether you have given sex. The other question of sex is covered by a different provision, which we have already done. So when you say conjugal rights, you are looking at basically the one the court wants to see is number one, cohabitation. Number two, society and comfort. You understand that the society, the parties are they are going out together. The marriage is preserved before third parties. Nobody is saying they are not living together. They are living together, but they cannot. The court is not looking for the question of sex in this particular matter. They are looking for basically cohabitation.
Okay, thank you.
Okay. Yes. So, say it again. Hello?
Ma, we can hear you.
We can hear you, ma.
Okay. Can you hear me?
Yes,
Yes,
ma, we
ma.
can hear.
I don't know what is happening with this phone. Anyway, so we go to H. I can't even tap anything. I can't see anything. Okay, so we go to H. What favor can you read H to us?
Ma, Section 15(2)H, that the other parties to the marriage has been absent from the petitioner for such a time and in such circumstances as to provide reasonable grounds for presuming that he or she is dead.
Okay. Now go to section 16. I can't access my go to section 16. 16, the last subsection.
Okay, Section 16(2).
Yes.
Section 16(2), where a petition is based on the facts mentioned in Section 15(2)H of this Act. A. Prove that for a period of 7 years, immediately preceding the date of the petition, the other party to the marriage was continually absent from the petitioner, and that the petitioner has no reason to believe that the other party was alive at any time within that period. It is sufficient to establish the facts in question, unless it is shown that the other party to the marriage was alive at a time within that period. And a decree made pursuant to the petition shall be in the form of a decree of dissolution of marriage by reason of presumption of death.
Okay. Again, what do we think about this provision?
I think it is okay because it provides the petitioner the opportunity to move on in a case of such a disappearance of his or her spouse.
Okay, so for 7 years, this person should be just around looking for somebody who. Do you think that? Yes. I'm listening.
My thing is another redundant provision, because why does the petitioner have to wait 7 years? Yes, ma'am. So my thing is a redundant provision, because why does the petitioner have to wait 7 years? I'm thinking that maybe the petitioner can bring an action under this 15(2)(f) for living apart, but that one is
Exactly.
for the 3 years. Yes, ma'am.
Yeah,
So
but
the petitioner, yes,
maybe
ma'am.
okay. Why don't you? Do you want to look at it from the other perspective that okay, these two people actually love themselves. The marriage is a good one. Okay, so maybe for some reason the other party, actually is really missing. So now this particular law aims at now freeing the person who is waiting to now get on with his or her own life. In other words, that this provision aims at a good marriage. It's not like the H, the G, which actually is a very redundant and senseless provision. But this particular one seems to be aiming at the marriage is a good marriage. Then all of a sudden, one party is lost or missing. The other party obviously loves wants the marriage and loves the party who is missing. But after waiting for 7 years, in this particular case, the law is aiding that person to move forward. Okay, 7 years, you can't continue to wait. Let the law release you, give you a decree that this marriage ended, not because you wanted it to end, but because we want the society wants you to move forward. Can you see it from that perspective? Which is
Yes,
why
ma.
which is why section 16 states that the decree for the solution must state the reason that it's because of presumption of death. Yes, let me hear your views on this.
Hello, ma.
Hello,
Mm,
ma. Hello,
yeah.
ma.
I think it will be applicable in the time of slave trade when they take a husband hostage and sell him to another country, and the wife waits, maybe you get released, maybe you run away. So after waiting for 7 years, and if he doesn't show, then she can go ahead and marry someone else.
Hello, ma. Hello, ma. Are you there?
Yes, I'm here, but I can't see your hand. So just talk if you want
Oh,
to speak.
my
I'm
hand
hearing.
is up. Okay,
I
ma.
can't
But for me,
Mm.
for on my part, I think I would have to consider situations of soldiers who end up like missing in line of duty, like they are MIA, and then maybe for the soldier somewhere who is really in love with his wife, he keeps counting down the days until he will finally, reunite with her, and maybe situations arise that do not exactly allow him to, to back home until 7 years after, until 10 years after, finds out that, oh, the wife is remarried. But at the end of the day, in my own opinion, the court does not, I really don't think the court exactly needs to concern itself with this, because it all depends on the parties to the marriage. If they decide to move ahead, then they can move ahead, and maybe in case of anything coming up and maybe the person comes back, they can bring an action that, oh, it was because of this that, okay, I had to move ahead with my life, get married to somebody, and maybe bring an order to say that, oh, please, I pray that, okay, let's bring a petition or a prayer to the court that, please, can you help us dissolve the first marriage,
But then,
even maybe in absentia.
let me chip in something. But what about the provisions on bigamy? What then happens if if the person moves on without dissolving this particular marriage? Then there will be bigamy.
Now that's what I'm saying, that maybe well, it depends on the party. Like the choice should be that of the party to come first to say, okay, in absentia of the other party, let me dissolve this marriage. Not that the
Okay.
court makes a provision that 7 years after come to
Okay.
the court.
Okay.
That's just what I'm saying, that the choice
Okay.
should be left in the hands of the parties to either
Okay.
decide to dissolve or not.
Okay. Okay. All right. Yeah, I see what you're
Yes,
saying.
ma'am.
Yes, I'm listening.
Okay, ma'am. So just to add like to what has been said, I like that you just mentioned the bigamy aspect of this, because I think it is really essential to a lot of what the law contemplates to like control, right? So I think seeing this from two perspectives, there is a perspective of a party or the spouse not hearing from their loved one for up to 7 years and whether they have to wait that long, right? I think if a spouse has a better half who has not communicated in a long period of time, it is easy for them to come under the provisions of G, right, of the 3 year or the 2 year fact of evidence, right? But I think this particular provision is specifically catered or meant to cater for situations where someone has genuinely gone missing and the other party to that marriage, though concerned, has gotten to a point where mentally they have moved on. In fact, the entire situation could have amounted to an exceptional or hardship for them, having to stay that amount of time without hearing from their better half. Right. I like the fact that you mentioned earlier that this can be a provision where the marriage is not exactly bad, right? Maybe there's a good relationship. And so I feel like the law understands that there are situations where someone has gone out of contact and the other party knows they are alive, right? But the person is just not choosing to have contact. But this one is for where you want to come to the court and say, I don't want to do bigamy, but it's like my spouse is dead and I've waited 7 years. So it's just opening up an avenue where a spouse in that kind of situation can 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 avoid inadvertent bigamy and get
Exactly.
a legal dissolution of the marriage and move on with their life.
Yeah, I agree with you. It's just that the time may be a bit too long. What do you think about that?
Should I respond?
Yes, please.
Okay. So I think yes and no, right? I think it depends. I say no because if you look at the provisions of the Evidence Act under Section 164, right, it provides for in the general basis of things where you talk about presumption of death, the legal requirement is 7 years. That's for any situation, right? So if someone has gone missing and like for 7 years, they have not been made, like they have not been contacted, they have tried, they have not found the person, they can be presumed dead after 7 years on evidential basis, right? So I think the provision of the Matrimonial Causes Act applies this general evidential rule, right? So I say no because in the contemplation of the law, generally 7 years is reasonable time to presume someone dead. Then I say yes because if I have a wife, for example, and I have not heard from her for 4 years, even in fact 4 years is much. Imagine I have a good marriage and I've not heard from my wife for 1 year. Under normal circumstances, if you have not ended in some sort of maybe malice or some sort of like bad blood, I just don't hear from my wife in 4 years or 5 years. That's a lot, right? So I say yes because it is a long time for you to wait for someone, even when the person is known to have gone missing, right? It depends on the situation on ground.
So
So
that's why I think we must say that the time is too long. Because if somebody has gone, if the spouse would at least maybe need comfort or closure, so 4 5 years would have been more ideal than 7 years. When it comes to marriage, matrimonial causes, it should not be the same thing with other issues. With the General Evidence Act, that one, a lot of things are involved. Uh, um, uh, Succession, issues of succession, and dissipation of wealth. Dissipation, do you understand? So in that case, 7 years may be adequate because then you don't want the person to turn up and the person has no, some people have shared his properties, distributed his money, he has nothing to fall back on. But in the case of marriage, it's more intricate because the party who is waiting for somebody for so long may need comfort and may need to move on. And so in my view, 7 years is too long. So it should be something nearer 4 or 5 years. Anyway, I think we can close dissolution with that. Dissolution of under statutory marriage. I will just talk briefly on dissolution of customary law marriages, um, which is part of the topic we are to treat. The solution of customary law marriage, it depends generally on the custom that is involved. But I think one can say that on a general rule, I would like to take your own views on this too. On a general position, it is difficult to say that customary law marriage can be dissolved unless in the case in which the courts are now doing it, the customary law courts and the area courts are now doing it. But in real times, under customs, customary law marriages are not dissolvable. They seem to be in perpetuity. And the reason why it seems to be in perpetuity is because the customary law marriages vest the right of custody, if not ownership, of children in the man. So women are generally unwilling to leave marriages. And so, generally, unless in very exceptional cases, and what are those exceptional cases that may make customary law marriages dissolvable? It is clearly a fault-based regime because there must be an allegation of witchcraft or one of these very heavy issues that can lead to the marriage being dissolved. And what is the signet that the marriage is dissolved under customary law? It is that the bride price is returned. The bride price is returned by the wife's family. So now, in customary law marriages, in customs where the bride price is in signet, is not just monetary, how do you return the bride price? How do you return the bride price? So we can say that customary law marriages are generally not dissolvable, but exceptionally they may be dissolved. And the evidence of dissolution is return of the bride price. But we see that in customary law dissolutions, even when the wife's family wants to return the bride price, the husband can continue to avoid the return of that bride price. Because if the husband's family is not available to take the bride price, or even when the husband is the one demanding dissolution and requests the wife's family to bring back the bride price, the wife's family generally will refuse to return the bride price. Are you still with me?
Yes, ma'am.
Yes, ma'am, we're here.
Generally, the bride's family will refuse to return the bride price. And if they refuse to return the bride price, the marriage continues. The marriage is still in existence. So now, in modern times, what seems to happen is that the customary courts seem to then say, okay, return the bride price to the court. And the customary court issues a dissolution by fiat. And what do you think about that? What do you think about that situation? And then there's another intricate thing I want you to bear in mind. In Nigeria, we do double-decker marriages, as one author has put it. Double-decker marriages. You do the marriage under custom and you do it under statutory marriage. In legal, by way of legal theory, if you end the statutory marriage, the customary marriage is still in place, right? So the couple have the marriage is still subsisting, right? I want to hear your views on these issues I'm raising.
Yes.
If you have done two marriages, you have done the customary marriage. The evidence that a customary marriage has ended. Are you hearing me?
Yes, ma'am, we can
Yes,
hear
we
you.
can.
The evidence that a customary marriage has ended. Please, can you mute your phone? The person who is disturbing the class. You mute your phone, please. So the evidence that customary marriage has ended is return of bride price, right? And then this couple also conducted statutory marriage. So they have the marriage has been dissolved on based on section 15.2 that the marriage has broken down irretrievably, statutorily. Now, what happens to the customary marriage if
Okay,
the bride price has not been returned? Yes.
well, based on what Professor, because this was an issue in one of our previous classes,
Yeah.
but Professor Adekile said that the subsequent statutory marriage that occurs, she used a particular word. I think overshadow is not the word she used, but more like covers the customary marriage. So it then is just one marriage really, and that is the statutory marriage.
Well, yes, that is Professor Adekile's view. So this is why, in my own class, I try to make you have your own view. Because it's a university. It's not a secondary school and it's not a primary school. Do you understand? You are lawyers. You should have your own view. What is your own view?
Yes, ma'am.
I think that the marriage is still existing because even though it can be said that for some people they say that the statutory marriage has swallowed or overshadowed the customary marriage. I feel that the customary marriage and the statutory marriage, they are different because even the law provides for it that you can't get married to another person statutorily while a customary marriage is still in existence. So even if the statutory marriage has been dissolved, I feel the customary marriage is still in existence until the bride price has been returned, and maybe whatever formality that each custom demands is undertaken to ensure that the marriage has been totally dissolved, both on the part of both statutorily and customarily.
Exactly. Yes. Does any other person have some other view?
Yes, ma, I do. I have a maybe slightly different opinion.
Okay.
So, ma, I think because we already know that in the eyes of the law, once a statutory marriage has been conducted, it overrides, right? That's the contemplation of the courts on those issues, right? But I feel like in practical sense, that marriage
What
might
is
not
your
have been.
authority? What is your authority for that? What is the case law? The
Unfortunately,
case law.
I don't have
Because you
anyone
can't
ready
have,
in mind now.
you cannot have any case law authority on that.
Okay, I, let me just quickly search. I know there's a case on that, but I don't have it readily in my mind now, ma.
You are not likely to have any case. I'm sure you're trying to refer to Jadeshimi and Okotiebo. That is not what the case talks about. Anyway, I want to hear your views. Keep going. Go on.
Okay, ma. So I was saying, even though the customary marriage still exists, I think since both parties were involved in a case where they had to go to court and have their marriage dissolved, I think it would be very precarious for any party to still want to claim conjugal rights on that customary marriage, because it's not like the dissolution was done without their awareness. And so if they are to come and want to claim that a customary marriage still exists, I think it would be very precarious for any of like the parties to
No,
do something
you
like that.
see, you see, what you have to look at is legal theory. You understand? You are not looking at you have to look at you have to think in terms of theory of law. There is a marriage in a different system. And that is why the Marriage Act itself makes provision on the question of if you marry under customs, what happens with your statutory marriage? Can you come and marry under statute? In fact, the argument in under the Marriage Act is that it's even is even a form of uh, 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 it's a form of bigamy. Because if you marry somebody else, if you do a statutory marriage under Marriage Act, you can't go and do customary law marriage with the same person. That is what the Marriage Act contemplates. So, well, in my own view, there are two different legal frameworks, two different theories, legal theories underlining both marriages. So, if you have a situation where somebody has done two marriages, customary and statutory, you must take effective steps to break the two. You cannot say that the statutory one swallows up the first one, because it does not. If anything, the statutory one, if you conduct a customary marriage and you are saying that the statutory one is swallowing up this, it's an illegal act. Do you understand? It's an illegality. Because when you conduct a customary marriage, number one, it is potentially polygamous. It means that the man can marry more wives. Right? The man can marry more wives. Then that is a different legal framework. It's a different law regime. It's a different legal regime. Then you go and do the statutory one. That statutory one is in conflict with the original legal regime. And that is why the Marriage Act says that to make allowance for the Nigerian situation, if you've done the statutory marriage, you cannot go and do the customary marriage. But if what you've done is customary marriage with the same person, you can still do statutory marriage with the same person. But it's all a question of reality check. As long as the marriage is there's no problem with the marriage, there's no problem. But once there's a problem with the marriage, then a problem arises for law as to what do you do with the different regimes. The only thing to be done is to end both regimes in the formality, according to the formality prescribed by both regimes. Now, the way the foreign jurisdictions, because this became a very serious matter after a Nigerian couple who were married in England, but also did customary marriage, had to go to court. I think that's the case of Ohoku and Ohoku. What is the title of the case? Is not Ohoku and I do some name like that. Some funny name. Huh?
Ohochukuma.
Exactly.
Ohochukwu
Yes.
and Oho.
No, I don't think it has Chukwu attached to the name. There's no Chukwu attached to it. Something Ohoku anyway. Anyway, now the judge said he could only end the statutory marriage. He did not have jurisdiction to end the customary marriage. And I think that is the correct position of the law. That's the correct position. The correct position is that if a customary marriage is in existence and somebody does the statutory marriage, if you want to end the marriage as a lawyer, as a sensible lawyer, you should take effective steps to advise both the parties that the customary law marriage must be properly brought to an end, and the statutory marriage also properly brought to an end for the marriage to actually end. And so, even if the customary form of the families does not work, then you make sure you go to the customary court, and a customary court actually ends the customary marriage as well as the statutory marriage. Do you have any further comments?
Good afternoon, man.
Yes, good afternoon.
Yeah, I actually just want to make reference to the fact that there have been judicial pronouncement on this issue, that where a person marries a particular person under customary law, then proceeds to marry the same person under the statute, that the customary marriage is subsumed in the subsequent statutory marriage, such that.
Can you give us the case, please?
There is the case of Odive and Nwike Obo.
Yeah.
Odive and Nwike Obo, and also there's the case of Okon
decided
and
by
Administrator General. Ma?
Yeah, decided by. What did the court say? What did the court say precisely?
What the court say precisely is that concerning customary and statutory is that the two marriage merges, that the two marriage do not coexist. A customary marriage merges with the ordinance marriage and loses all its distinctions and characteristics, its legal incidents and consequences. That's exactly what the court said.
Read again.
And also, it says that the two marriages do not coexist. A customary marriage
The two
merges with
marriages
the
what?
ordinance do not coexist.
That is all I want to hear from you. Yes, go on.
A customary marriage merges with the ordinance marriage and loses all its distinctions and characteristics, its legal incidents and consequences. Then, in also Jadesimi and Okotebo, Ashiki GC actually said that where the same parties undergoes a form of marriage under customary law and subsequently go through another marriage under the Marriage Act, such second marriage converts without doubt the customary law marriage that was potentially
You have to read
polygamous.
cases. You need to read cases within their context. What was this? What I was the one who mentions Jadeshimi Okotiebo and Okotiebo to you now. What was the issue in Jadeshimi and Okotiebo? What was the issue? And if you listen carefully to me, I said to you that as long as there's no quarrel between the parties, this seems to be okay. But once there's a quarrel between the parties, and the solution is what was the subject matter of Jadeshimi and Okotiebo? What was the subject matter? Why were the parties in court? Are you still there? Are you still there? Have I lost this class? Are you still there?
No, ma, we can still hear you.
Yeah,
We
so
can hear you, ma.
what was the subject matter of Jadeshimi and Okotiebo? And Okon and the other case you're talking about, was it decided under the Marriage Act or under the Marriage Ordinance? So these are the issues you have to resolve before you cite these authorities. At any rate, it's a continuing debate. But I've told you my own position. You may choose to do your own. I've told you my own position. And then, of course, there are academics that say that when it comes to this issue of statutory marriage, you see, this is one area that the legislature in Nigeria must take a specific position, okay? And that specific position, why do you think people go on to do customary marriage and then also do statutory marriage? In fact, in many cases, it is the women who insist on customary marriage. They don't want the statutory marriage alone because without the customary marriage, they don't feel they are married. So you cannot, as the law says in many cases, benefits and burdens, you take them together. You cannot go to statutory marriage just because it's monogamous and say, oh, that is the one I want. It overrides the customary. That is not the way law works. Law works by theory and framework. And so you follow the framework and the procedures and formalities of each one. You don't pick and choose. So what happens in Nigeria is that people are doing two different marriages. And it is for the law to come out straight to state that customary marriage is customary marriage and make provisions, okay, that will shore up customary marriage. For instance, in Tanzania and even South Africa, okay, what they now do is to ensure that customary marriage is registered, okay, is registered. And then under their own customary marriage in Tanzania, if you have to take a second wife under customary marriage, you must get the consent of the first wife. and in South Africa as well. So the questions of a property distribution are all provided for statutorily, even though the marriage is customary. So you close loopholes for problems. If you look at the case of Jade Shimie and Okotiebo that we're citing, it was not based on dissolution. It was based on inheritance. And the other case that he's citing was based on marriage ordinance, not on the current framework of marriages in Nigeria. So there's only one way to go, and that one way to go is for the legislature to make proper provisions on how these legal frameworks, marriage frameworks, can conform to modern requirements that takes care of the fears of women that make women insist on. I know someone who was ready for marriage, but the man did not want to do customary marriage. He wanted to do only statutory marriage. One would have thought that the woman would be very happy about this, but the marriage broke down. The arrangement broke down because she wanted the customary marriage. And when I inquired of her, why was this? Because she was a former student in our faculty, and then her father is also a professor in the university. So I knew them pretty well. So she said she didn't feel like she was married by just going to do statutory marriage. So this is a very serious issue in Nigeria. It is not an issue that, can just be watered down by saying, no, the statutory one subsumes the customary one. You see, the statutory one can subsume the customary one if it's a question of inheritance. The man has died, and then maybe the brothers want to take over the property of the man. The provisions regarding succession will make it impossible for these brothers of the man to lay claim to customs to be able to take the property of the wife. But when it comes to dissolution, that principle cannot work. So we are discussing dissolution of marriage. So that subsuming cannot work with respect to dissolution. Both marriages must be properly ended. And that is my position. And it's up to you to take whatever position you want to take. Now, based on this note, I want to close this class. Dr. Ibrahim will take you on Islamic dissolution of marriages under Sharia law, under the Sharia in the coming week. So the class rep should please contact Dr. Ibrahim and remind him of this. Thank you very much for the class. Are you still with?
Thank you.
Okay.
Bye.
Thank you, ma.
All right. So thank you very much.
Thank you, ma.
Okay.
Ma.
Take care. Bye-bye. Bye-bye.
Thank you, ma.
Bye-bye. Thank you. Bye.
Bye.